Hello everyone and welcome to this video tutorial on robbery. The offence of robbery is contained in Section 8 of the Theft Act 1968. In criminal law, robbery is a form of aggravated theft in that it involves the offence of theft plus force or threat of force on a person. The maximum sentence for robbery is life imprisonment. Start by having a look at the definition of robbery from Section 8 of the Theft Act. A person is guilty of robbery if he steals, and immediately before or at the time of doing so, and in order to do so, he used force on any person, or puts or seeks to put any person in fear of being then and there subjected to force. So this looks like quite a long and complicated definition, but hopefully things that have jumped out to you are things like there's got to be a theft, first of all, stealing. And when the stealing was happening, some force or fear of force has been used. But let's break this down, as we always do, by having a look at the actus reus and the mens rea of the offence. The actus reus of robbery has two elements to it, and in order for a robbery to take place, we must have both of them. So firstly, there must be a completed theft, and secondly, there must be force or threat of force before or at the time of the theft. So in order to answer a robbery question, it's vital that you know your law on theft really well, because you can't answer robbery without theft, because it is a key element of the offence. Let's remind ourselves of what a theft is, because this is the first part of showing that we've got a robbery. So every element of theft must first have been satisfied. And if you recall from studying theft, we have 3 actus reus requirements and 2 mens rea requirements. So there must be appropriation of property belonging to another with the dishonest intention to permanently deprive. If any elements are missing here, you haven't got a theft and therefore you cannot have a robbery. And a case which illustrates this is the case of Robinson. The case of Robinson was that the defendant was owed money, £7, by a woman. He went to ask her for it, and a bit of a fight, a bit of a scuffle developed between the defendant and the woman's husband, or victim here. During the struggle, a £5 note dropped out of the husband's pocket, and the defendant picked it up and kept it. And he was convicted of robbery and appealed, and his conviction was quashed. There was no theft under Section 2(1)(a) of the Theft Act 1968 because the defendant had an honest belief in legal right to the money. In other words, because he was owed £7 and £5 has been dropped, in his mind, that £5 is his. So because he wasn't dishonest for theft, there couldn't be a robbery either. So the case of Robinson gives us the principle that we must have a completed theft before there can be a robbery. So let's consider the second actus reus requirement for a robbery. Once we're sure we've got a theft, we then have to look at what is force or threat of force before or at the time in order to steal. So the courts have had to consider what the word force means. And our first case on this is the case of Dawson and James. From the case name here, we had 2 defendants who were involved in the robbery of the victim. One of the defendants in this case nudged the victim so as to make it easier for the other defendant to take the wallet from his pocket. And the jury convicted both of our defendants of robbery, and our defendants appealed, saying that nudging somebody wasn't enough to be classed as force for a robbery. But the court disagreed, and it was held that the word force is to be given its ordinary meaning, and it requires no direction to the jury. The force used can be slight, and it is up to the jury to find that force has been used. There's no requirement that the force is directly applied to a person, and this is illustrated by the case of Cloudin. In this case, the defendant wrenched a shopping bag from a woman's grasp. And although he didn't physically touch the woman herself, it was held that the force used on the bag was sufficient to amount to force used on a person. A slightly more controversial case on force here is P and the DPP. And the facts were that the defendant snatched a cigarette from the victim's hand without touching the victim in any way. So in other words, he's grabbed the cigarette and slid it out of her fingers, if you like. He hasn't actually touched her. So this is different from Clouden, because in Clouden, he was wrenching the bag, the victim was pulling back, so there was force there. Whereas here, he's slid it out of her hands without there being force. So it was held that this wasn't a robbery because force hadn't been used on a person, there was no direct contact between the defendant and the victim, and as I've said, it's different from Clouden because there was no wrenching going on here, it was slid out, so there wasn't enough force for it to be a robbery. The actus reus of robbery allows force, as we've just discussed, on the victim, but it also allows for the threat of force or the fear of force. So in a classic robbery situation, you've got a defendant pointing a gun at a victim saying, "Give me all your money." In that situation, they're not using force on the person, but they are creating a fear of force. To use this example from the case of The Terminator, you're probably too young and cool to know this film now, but there is a classic scene in this film where Arnie here goes into a pub and says in a very threatening manner, "I need your clothes, your boots and your motorcycle." Now this is quite interesting in terms of it being a robbery because he doesn't say, "I need your clothes, your boots and your motorcycle, or I'll kill you." But that's what we would call an implied threat, because from his conduct, the way he's speaking, that indicates, although he's not explicitly said it, that he's going to use force if that's not complied with, which he does if you watch the film. And that links quite nicely to this case of B&R and the DPP. Of this case was that our victim was a schoolboy who was age 16 and he was stopped by 5 other schoolboys and they asked for his mobile phone and money. As this was happening, another 5 or 6 boys joined the first 5 and completely surrounded the victim. No serious violence was used against the victim, but they took his mobile phone, £5 from his wallet, his watch and a travel card. And in this case, the victim said that he didn't feel threatened or scared, but that he was a bit shocked. Now, what the court said in this case was that there can be a robbery through an implied act. So a bit like I gave you with the Arnie example as well, that the conduct here of surrounding this boy, a big gang of people surrounding him and demanding things, can amount to an implied threat. And importantly, our victim doesn't have to be scared for it to be a robbery. And that's quite interesting because if you think back to the offence of assault, for an assault, you have to have a scared victim. And if the victim isn't scared, it's not an assault. But for a robbery, there's no need for there to be fear as long as we've got an implication that force is going to be used. The force can be on any person, and importantly, the person threatened doesn't need to be the person from whom the theft occurs. And classically, if you think of a bank robbery, this is a lovely way of explaining this. If a bank robber goes into a bank, he will threaten all the customers and he'll threaten the cashiers, but he'll actually steal from the bank. But it doesn't matter that he's threatened these people and stolen from the bank, as long as there is force on somebody and a theft. And it might be in a street robbery, for example, that maybe a wife is threatened and the husband gives the money over. In that situation, the threat is not on the person who's given the money over, but it will still be a robbery because there's been force on a person in order to steal. The next issue with the actus reus of robbery is that the force or threat of force must be immediately before or at the time of the theft. And this has posed some problems for the courts, which they've had to deal with in a couple of cases which we're going to look at now. The problem is that the offence of theft is complete as soon as the appropriation has taken place. So on a strict interpretation of the statute, use of force to escape with stolen property would fall outside the ambit of the offence. However, the courts have taken a pragmatic or a practical approach, and they've actually treated the appropriation of theft as a continuing act. So if we have a look at the case of Hale to explain this, the facts were that we had two defendants who forced their way into the victim's house. One of the defendants put his hand over the victim's mouth to stop her screaming, and the other one went upstairs to take a jewellery box. And before they left, they tied the victim up. Defendants were convicted of robbery, but they appealed on the grounds that the force came after they'd appropriated the jewellery box, i.e. when they tied her up, they'd already appropriated it, so the force wasn't before or at the time of the theft. And so they were saying that they didn't meet the requirements for robbery. In this situation, though, you can see that they had put their hands over her mouth before they took the jewellery box. So there was force before they took the jewellery box anyway. But the court did consider, what if they'd not covered her mouth up? What if they'd taken the jewellery box and the only force was when they tied her up, and this force would have then been after the theft? But the court said tying her up can be classed as being in order to steal. They believed that the theft was still continuing. The judge in this case said, quote, "To say the conduct is over and done with as soon as he laid his hands on the property is contrary to common sense and to the natural meaning of words. The act of appropriation does not cease, it's a continuous act, and it's a matter for the jury to decide whether or not the appropriation has finished." So what this means is, if someone steals something and then uses force in order to escape, it can still be classed as a robbery, even though the Act says that the force should be immediately before or at the time of the theft. And that's for a very practical reason that wasn't considered when Section 8 of the Theft Act was being written. Based on this same point was Lockley. Our defendant was caught shoplifting a can of beer. So he'd already taken the beer and was on his way out of the shop when he then used force on the shopkeeper who was trying to stop him from escaping. So here the force is after the theft. So he's saying he shouldn't be guilty of robbery because the force was afterwards, and the theft was complete when he used the force. But the Court of Appeal followed the decision in Hale, and they said the theft of the beer can was continuing and it was still ongoing when the force was used. So again, it's showing that if the defendant is using force after they've taken something in order to escape, it can still be a robbery. We've looked at the actus reus of robbery now. We know that we need a completed theft and force or threat of force before or at the time of the theft in order to steal. The mens rea for robbery has two elements to it. There must be the mens rea of theft, dishonest intention to permanently deprive, and the intention to use the force in order to steal. We already understand the mens rea of theft, that they've got to be dishonest, and they won't be dishonest if the situations in 2(1)(a) to (c) apply, and they've got to intend to permanently deprive the other of it. The bit we need to consider a bit more here is intention to use the force to steal. So to give you an example of this, let's say I punch Chris in the face just because I'm annoyed with him, and he falls on the floor and a £1 coin rolls out of his pocket, and I go, "Oh, that's handy," and pick it up. I didn't punch him in order to steal. I just punched him because I was annoyed with him. So in that situation, I'd be guilty of a battery and a theft. It wouldn't be a robbery because my force was not in order to steal. So that's what that element means. So we'll end here on a summary sheet. Our actus reus is a completed theft plus force or threat of force before or at the time in order to steal. And our mens rea is that of theft plus intention to use the force in order to steal.